This is Koteswara Rao dealing with land laws for the Adhikari Nama University. I am affiliated to the for the Faculty of Law in Koteswara Rao College. I am directed by the principal to take up the subject land laws for the 8th semester of the 4th year LL.M. That is 5-year LL.M. So the land law subjects, which is an important aspect as far as the concerning with the state. Before going to take up the various units or the subject, topics that are embodied in the land laws, this subject has been divided into 4 units, and the very first chapter, or what we call it as a unit 1, is consisting of the eminent domain and escheat. So what is meant by the eminent domain and escheat? Before going to take up these topics of eminent domain and escheat, and also the Escheat and Bona Vacancy Act 1974, it is not out of place to mention the characteristics of the state. What are the main characteristics of the state? So, the very first characteristic of the state is the people. As we know pretty well that the state is consisting of the people. There is no state that is being called as the state without the people. So, it is the paramount important aspect with relating to the people, that is called the population in general and particular, that a state should possess. And the second one is, you can take into consideration the aspect of the land. There will not be any state that is being called as a state without the subject matter of the land. That is, a state is being called as the state only when it possesses the land only. When it possesses the land. That is, we can take into consideration in general the territory of a particular state. Say for example India, Ethiopia, like that. So the Ethiopia is consisting of the so-and-so territory. It is being bordered with Eritrea, like that. So likewise, there is no state without people. There is no state without the land. And the third one is the government. That is, the third one is an essential element of the state, where a state should possess the government also. That is, a state is not being called as the state without properly elected government. So, if all these 3 aspects that are being covered, that is the land, people and government, then a state can be called as a state. And even the state is consisting of all these 3 elements, it cannot be absolutely, exclusively will be called as the state without it is not having the sovereignty. That means, even though it is consisting of all the land, people and etc. and government, it should be that government should be having the sovereign power. So, a properly elected government without the sovereign power to take any decision to take any decision with relating to the finance, with relating to the external affairs, with relating to the defense, if it is not having a sovereign power, it is not being called as the state. So if the state is consisting of all these four elements, then only we can technically call as the state. So for a statehood, now we being the students of land laws, we should be having the knowledge about the matters connected with the land. So of course, as far as the land is concerned, the proprietary right that a person should possess, all these things that we have studied in the various concepts relating to the previous subjects. Now exclusively we are dealing with the concepts with relating to the domain power or eminent domain. Before going to take up this eminent domain, we are calling it as the eminent domain, which has been embodied in the Indian Constitution under Article 300A and 31A of the Indian Constitution. That means the state is having an exclusive power to dispossess any person that he is having any land that he is possessing. So that this is somewhat a replica where we have gone through in the statutory authority that what we have studied in the, say for example, the general differences that are available in the hands of the defendants. So, and at the same time we have had the concept of the salus populi suprema lex, that is, the welfare of the people is the supreme law. That means the state is having an unequivocal right to take the land or the piece of land belonging to any person in the society if it requires, because the state is having exclusive power, sovereign power to dispossess a person from the land. So this eminent domain or the domain power of the sovereignty that is being vested or bestowed with the state is called, that has been in the Article 300A and 31A of the Indian Constitution. There is somewhat a slight difference with relating to the using of the police force and the eminent domain. Even with relating to the police force, we know pretty well that is a legal power, whereas if you take into consideration the eminent domain, it is exclusively the sovereign power. As far as the sovereign power is concerned, the rights are not available against the state, but as far as the legal power is concerned, the courts of law have got the exclusive power. And likewise, there is a difference between the taxation or the tax laws and the state, the eminent domain also. As far as the state taxation is concerned, the taxation cannot be imposed on the people who are having not sufficient amounts as incomes. It should be taxable income. When a person is having the taxable income only, then only the state has got the power to impose the tax laws on those upper strata in the society. As you know pretty well that there are two categories in the society, the lower strata people and the upper strata people in the society. As far as the lower strata people is concerned, the tax laws are not to be applicable. As far as the upper strata of the people is concerned, the tax laws are applicable. But here, in the case of the eminent domain, it can be used on both the sectors of the society, that is both upper strata and the lower strata of the people. Likewise, there is a difference of differentiation between the confiscation of property and expropriation of property. And at the same time, there is also the concept which relating to the bona vacantia. Bona vacantia is the replica or synonymous of the bona vacantia is the treasure tower. Treasure tower. So, as far as the bona vacantia is concerned, it is aspect relating to the bona vacantia is that if a person dies intestate, leaving behind him without the legal heirs, the concept of bona vacantia will come into the picture. There is bona vacantia, and there is one act that has been formulated in the year 1974. That is Bona Vacantia and Estates Act 1974. According to this Bona Vacantia and Estates Act 1974, the state has got the power when a person dies intestate with leaving the property without having the legal heirs. The state has got every power to usurp its exclusive sovereign right over those persons who had died intestate without any legal heirs. This is all about the concept related to the eminent domain and estates that has been embodied in the first topic of the Unit 1, where the characterization of the characteristics of the state are also being to be mentioned. My dear students, as far as the first unit is concerned, I request to prepare some answers for the following questions. One is bona vacantia. What is meant by the bona vacantia? The second one is the estates, and the third one is what are the essentials of the state that you are supposed to answer as to for the main area that has been provided. Thank you very much.